Good evening, everyone. Welcome back after the weekend. This is Lecture 5. Now, we are looking at the implied terms, very important, sections 13, 14, and 15 of the Sale of Goods Act. It comes up in the exams every year, and it comes up as a problem question every year. So we've started looking at these terms. We've completed looking at Section 13 of the Sale of Goods Act. Section 13 says there is an implied condition that where goods are sold by description, goods must correspond with that description. Goods are only sold by description if there is an express term as to description. So the first thing to establish is that the statement the seller makes amounts to an express term, and it is not a representation. We reminded ourselves of the factors the court will bear in mind. We then looked at Ashington Piggeries against Christopher Hill, the case about mink food causing liver disease. The House of Lords said there was no breach of Section 13. The herring meal was still herring meal. Diplock said, yes, the herring meal was contaminated, but no poisonous substance was added to it to make the description herring meal incorrect. The defect in the herring meal was a matter of quality, not description. Remember that Section 13 is subject to the strict compliance rule. In Arcos against Ronason, wooden staves were supposed to be ½ an inch thick. The staves delivered were 9/16 of an inch thick. That's just 1/16 thicker than agreed. Court said breach Section 13. Of course, nowadays, Section 13 is subject to 15 big A. If the breach is so slight, the court has a discretion to treat that breach not as a breach of condition, but as a breach of warranty instead. Now, if the buyer himself selects the goods, can it be a sale by description? The answer is, oh yes. Why? Because Section 13, subsection 3 specifically says so. In Beale against Taylor, a car was advertised as a 1961 white Herald convertible. The buyer examined the car, he bought it, and he took it home. The buyer then finds out that it was actually two cars that had been welded together, and only one half was a 1961 Herald. Court said, yes, breach of Section 13 description, even though the buyer himself selected the goods. As we said, in order for Section 13 to apply, there must be an express term as to description. If the contract term is that the suit is to be made of wool, if the suit is made of cotton or something else, then this would be a breach of the express term and a breach of Section 13. That's why we said, in a way, Section 13 is a little redundant, because Section 13 only kicks in if there is a contract term as to description. If description is an express term of the contract anyway, then there is no need for Section 13. So it's a bit weird, really, isn't it? Because essentially, Section 13 implies a term that the seller must comply with the express term. The only benefit, in a way, is that Section 13 is an implied condition. But nowadays, this is subject to 15 big A. So it's not so different to express terms anymore. Because if there was a breach of the express term, then that term is treated as an innominate term. Just see how serious the breach is. Sometimes it's so serious, it'll be treated like a condition. Sometimes it's not so serious and it will be treated like a warranty. You and I know the case from contract law, Hong Kong First Shipping against Kawasaki Kaisen. Now, We also said that quality sometimes forms part of the description of the goods. The good example here is Lord Denning in Topfer against Continental Grain. He gave us an example. He said, new laid eggs. He said, new laid goes to both description and quality. So if the eggs are not new laid or they're not free range, the buyer can usually sue the seller for both breach of description as well as quality. Not any old eggs, they must be new laid eggs. It identifies an essential ingredient. So if the buyer will sue the seller under section 14, then the buyer's argument would be that new laid eggs implies not merely that the eggs are literally new eggs, new laid, but that they are of good quality, because that is the natural implication of the words. We then looked at section 14. As you know, section 14 only kicks in if the seller sells in the course of business. But selling in the course of business is given a very wide meaning. In Stevenson and Rogers, even a fisherman selling his old fishing boat is selling in the course of business. One of the main subsection numbers is section 14 sub 2. It is an implied condition that goods must be of satisfactory quality unless, and there are two exceptions, unless the defect was specifically brought to the attention of the buyer or the buyer's examination ought to have revealed the defect. Now, once you have established that the exceptions do not apply, then you need to discuss the meaning of satisfactory quality. The definition is under section 14 sub 2 big A. 14.2 big A says, goods are satisfactory if they meet the standard that a reasonable person would regard as satisfactory, taking account of three things: description, price, all other relevant circumstances. Then go through each one. As far as description is concerned, you know that we have 2 second-hand car cases and we have 2 brand new car cases. So when we talk about description under 14.2 definition of satisfactory quality, we're asking really whether the goods are second-hand or are they brand new? How are they described? Well, as far as second-hand goods were concerned, we looked at Bartlett against Sydney Marcus. Remember, the second-hand car, the clutch was just a little bit stiff. It was perfectly fine, you can drive it. The clutch was just a bit stiff. Court said, that's okay. Satisfactory. Second-hand goods, it's fine. Crowther against Shannon Motors, second-hand car, but this time the car just clapped out. It broke down after almost no time at all. The court said, well, even second-hand goods must be roadworthy for a reasonable length of time. So the court said, breach 14.2, even though it was a second-hand car. Of course, if the goods are described as new in Rogers against Parrish, it involved a brand new Range Rover. And if you remember, it was fine, except there were just a few scratches here and there. Mr. Justice Mustill said, well, when somebody buys a brand new car, a few scratches might render that car unsatisfactory, because when you buy a brand new car, it involves the pride and joy of driving around a brand new car. So, few scratch marks, breach satisfactory quality, breach 14.2. Of course, we then looked at Bernstein against Pamson Motors, a brand new Nissan. When he was delivered to the buyer, he was an old man and he was sick. So he didn't drive it until he felt better, which is about 3 weeks later. Almost the first time he drove it, broke down. The court said, of course, breach of 14.2. This was a brand new car. Claps out, breach. We come back to this case later on, Bernstein against Pamson Motors. Now, whether the goods are satisfactory also depends on price. we looked at the case of Brown against Craigs. This was a contract for cloth. The parties did not specify the type of cloth, but they did agree on a price. When the cloth was delivered to the buyer said the quality of the cloth was unsatisfactory because the buyer, remember, he was expecting high fashion material, stuff he was going to make clothes with. The court said, well, the price agreed was too low for fashion cloths, which was what the buyer was expecting. The price was nearer to industrial cloth, which is what the seller delivered to the buyer. So the court said, no breach, 14-2. The cloth was satisfactory. Of course, description and price are not separate tests anyway, and a very good case to illustrate this is Felderall Foundry against Hermes Leasing. The MD of a foundry company loved sports cars. The company bought him a second-hand Lamborghini. The cost was £65,000. The car was defective. The defect in the steering meant that it was potentially unsafe to drive at high speed. Now, the cost to rectify this problem was only £1,000. So the finance company argued there can't be a breach of 14.2 because the cost to repair is only £1,000. So it's okay, it's satisfactory. The court said, no, this was a breach of 14.2. It was unsatisfactory, even though it would only cost £1,000 to repair. Sure, the description was second-hand car, but bearing in mind the very high price paid, the court said a reasonable person would not regard the Lamborghini as satisfactory. Now, we also looked at the very odd case of Bramhill against Edwards. The buyer bought a US motorhome. It was 102 inches wide, but the maximum permitted by UK regulations is 100 inches. The buyer used this motorhome for 6 months, and then for some crazy reason, he decided that he would measure it. And then he found out it was 102 inches wide. The buyer continued to use it, but he waited another 6 months before he sued the seller, arguing that the motorhome was not of satisfactory quality because it could not be driven on the UK roads without committing an offence. Remember, I mentioned that there was evidence in court that the police knew that US motorhomes were 102 inches wide, but the police said, oh, we just turn a blind eye to this illegality. The Court of Appeal said, no breach of 14.2. The motorhome was of satisfactory quality. Now, this is an odd case because it seems that a vehicle sold for use on British roads is satisfactory, even if it is a criminal offence to drive it. But the Court of Appeal was not sympathetic to this buyer. After all, the buyer didn't complain for 6 months. And even then, even once he knew it was 102 inches, he still continued to use it for another 6 months before he wanted to sue the seller. Now, that's where we got to on Friday evening. Compare this case, Bramhill, compare that with Lowe against Mitchell. Mr. and Mrs. Lowe were converting a barn for residential use. They ordered a one-off staircase, which they themselves designed. The cost was £16,000. When it was delivered, the staircase did not meet building regulations, so the buyers rejected. They said this staircase is a breach of 14.2 and 14.3 because it was illegal to use it. The Court of Appeal said, yes, breach 14.2. The staircase could not lawfully be used in residential premises, so a reasonable person would not find the goods satisfactory. It was also a breach of 14.3 because the seller knew the purpose of the staircase. They knew it was going to be for residential use. So the seller knew that it needs to be compliant with building regulations. It was reasonable for the buyer to rely on the seller's skill and judgment. So there was a breach, 14.2 and 14.3. But there's a bit of a problem here, isn't there? I mean, the buyer got exactly what the buyer specified. Remember, the staircase was to the buyer's design. But if you use the staircase, then there would be a breach of the building regulations. It was illegal to use it as intended. That's why the court said breach of 14, section 14. But if the builder modified the specifications to make the staircase compliant for building regulations, the builders would be in breach of section 13 description. How do we reconcile this? Well, Lord Lloyd said the seller should have pointed out the building regulations problem before he accepted the order, or at the very latest, before the design was finalized. Then the buyer had the choice to go ahead or not, because you see, liability under section 14 is strict. Now, if this case was brought today, of course, it would fall under the CRA, the Consumer Rights Act, because Mr. and Mrs. Lowe are consumers. We will study the CRA, of course. The CRA gives the buyer the right to demand repair or replace. We're looking here at the definition of satisfactory quality. Whether a reasonable person would regard the goods as satisfactory depends on description. We've done that. Price. We've done that. The third thing to take into account is all other relevant circumstances. There's only one case on this, Lamara against Capital Bank. Let me tell you about this case. Lamara involved a brand new Range Rover. There were very minor defects. The ashtray was a little bit scratched. Anyway, the buyer wanted to reject. The seller argued, this defect is easily rectified. And anyway, they said, it was covered by the Range Rover warranty. The seller said it's unreasonable for the buyer to refuse their offer to remedy these defects. The buyer, you see, wanted to reject. The court said, having a Range Rover warranty is not a relevant circumstance to determine whether the goods are satisfactory or not. The reasonableness or unreasonableness of the buyer, it's not relevant at all. Why should a buyer who has a warranty be in a less possession than a buyer with no warranty? If the buyer has the right to reject, the buyer can be as unreasonable as he wants. Good faith, bad faith does not come into it. If there is a breach of a condition, the innocent party can always reject. This is true, even if the buyer is rejecting only because the market price of the goods is going down. Of course, nowadays, we must bear in mind section 15, big A. Now, section 14.2b says the following are aspects of the quality of the goods: fitness for all purposes for which goods of this kind are commonly supplied, appearance and finish, freedom from minor defects, safety, durability. As far as this first bit is concerned, goods must be fit for all purposes for which goods of this kind are commonly supplied. Well, that's causing us a little bit of a difficulty, because we're not sure if the case of Aswan Engineering against Lupdine is still good law. You see, Aswan Engineering always said the goods only have to be fit for one purpose. In Aswan Engineering, wooden barrels were satisfactory for most purposes, just not for the very extreme temperatures in Kuwait. The court said the wooden barrels were satisfactory. Goods only have to be satisfactory for one common purpose. That case has always stood. But now we've got 14.2 big B, which is an amendment. It's saying goods must be fit for all purposes. What I'm saying is we're not really sure what that means. Does it mean Aswan Engineering is no longer good law? Let me make up an example. Let's say I go to a shop and I buy a Ming vase. I pay 20 million US dollars for the Ming vase. Now, you tell me, why would I, or why would anyone pay 20 million US dollars for a Ming vase? You tell me, why would anyone pay 20 million US dollars for a Ming vase? You tell me. Lots of ideas. Why would anyone pay 20 million megabucks for a Ming vase? Why? Why would anyone do that? Yeah, yes, I agree. It's because it's an antique, it's exclusive, it's a thing of beauty, it's perfect condition. I agree with you. I agree. Now, whatever the reason, I pay 20 million for a Ming vase. I'll tell you what I'll do. I take the Ming vase home. I put a bunch of flowers in the vase. I put some water in the vase. You know what happens? It leaks. Can I claim the seller is in breach of Section 14? The Ming vase is not of satisfactory quality. Can I say that? Because you see, 14.2b says goods must be satisfactory for all purposes. So not only must it be satisfactory as a Ming vase because it's a thing of beauty, it's an antique, not only must it be brilliant for that, but it must also be satisfactory as a vase. Well, it's very difficult this, but I suppose it doesn't sound very likely, does it? I mean, 14.2b does say for all purposes, but I think we can probably argue that 14.2b is just talking about an aspect of quality. I mean, let me give you a less dramatic example. Supposing the seller sells me a broken chair. He says, oh, I'm selling it cheap because I'm selling it for firewood, for you to use in a barbecue. Now, I can't claim the chair is defective because it was sold to me as firewood, even though a common use of the chair is to sit on it. Now, I think all we can say is that although 14.2b says goods must be fit for all purposes, the definition of satisfactory quality is in 14.2a. Goods are satisfactory depending on description, price, or other relevant circumstances. 14.2b merely says, hey, P.S., these are other aspects of quality. Aspects of quality does not form part of the definition of satisfactory quality. Just things you might want to consider, just aspects. That's all we can say until we have case law that says otherwise. To the question, when must goods be satisfactory? Well, the answer is at the time of sale and return. Now, Crowther against Shannon Motors, we looked at this case earlier. It was one of the second-hand car cases. That broke down after no time at all. Because the question is, well, if goods must be satisfactory at the time of sale and delivery, well, how do I know that the goods are defective or not? Because when you deliver the goods to me, I don't know at that point in time whether it's of satisfactory quality or not. Now, what Crowther against Shannon Motors is saying is if goods are defective after a short period of sale, that is evidence that at the time of sale and delivery, the goods are already defective. We already looked at the case of Hazelwood against Lion Foods. Remember, the FSA, that's the Food Standards Authority, had zero tolerance as far as para-red at the time of sale and delivery. It was irrelevant that a few months after delivery, the FSA's new guidance on the level of para-red allowed was higher than found in the chili powder at the time of delivery. So there was a breach of 14.2, there was a breach of 14.3. Because the relevant time of when goods are to be satisfactory or fit, answer at the time of sale and delivery. There are a couple of questions in the chat thing, so let me have a look at that. But you say you're buying a really exclusive, expensive good, say a watch, but there are some parts of it that does not work. Will it still pass the 14.2b threshold? Of course the answer is no. Forget 14.2b, it's not even going to pass 14.2a. If this is a brand new high-priced goods, we know the cases, right? So I don't need to repeat them. We've seen Rogers against Parrott, a few scratch marks in a car. That would render the goods unsatisfactory. If the parts are defective, the parts form part of the goods, right? That would be a breach of 14.2. Implied condition, very serious breach indeed. Now, let's say the question here also is, if the seller had described the vase as a Ming Dynasty antique, the buyer would not be able to reject. No, but that was the query I've just given you. What I'm saying is, why would anyone pay such a huge amount of money for an antique? Well, the answer is because it's an antique. Thing of beauty, reinvestment value, whatever. But does it have to be good enough as a vase as well? Does it have to be good enough as an antique Ming vase and good enough for me to put flowers in and put water and it doesn't leak? What we're saying is, well, we're not sure. 14.2b seems really clear. It's got to be fit for all purposes. Not only as an antique, it's also going to be good as a vase. But that doesn't sound very reasonable, does it? So that's why I'm saying I think 14.2a is the super important section number, because 14.2a gives us the definition of satisfactory quality. 14.2b is just saying, here are just a few aspects. Oh, you might want to take these things into consideration. It's just like a secondary thing. So I think 14.2a overrides 14.2b. Okay? All right. But when you say it's an old one, antiques invariably are old. It's not an antique if it's 2 months old. That's just secondhand, right? So I'm talking about $20 million worth of a Ming vase. Ming invariably is already old. It's an antique. That's what I'm talking about. All right. Let's leave that point. Let's move on to section 14 sub 3. Now, 14.2 sub 3, whoops, up there. 14 sub 3 talks about fitness for purpose. 14.3 says this. 14.3 says, where a buyer expressly or impliedly makes known his purpose, it is an implied condition that the seller must provide goods fit for that particular purpose. Again, there are 2 exceptions to this term, to this implied term. Now, we will look at the exceptions in a minute. But in order for 14.3 to apply, the buyer must have expressly or impliedly made known his particular purpose. He must have expressly made known. Well, let me give you an example. Let's say I go to a shoe shop and I say, oh, I need a pair of shoes to go mountaineering in. I want to go hiking this weekend. I need a pair of shoes suitable for that. What the shopkeeper sells me is he sells me a pair of shoes, 6-inch heels. Now, of course, it breaks when I go mountaineering. Now, I have expressly made it known to the shopkeeper why I need the goods. So if it is not suitable for that particular purpose, the shopkeeper is in breach of 14.3. Now, 6-inch heels, there's no breach of 14.2. No breach because it's probably of satisfactory quality. It's just a breach of 14.3. When 14.3, the seller must give me goods fit for my particular purpose because I've expressly told him why I wanted the pair of shoes. So no breach 14.2, yes breach 14.3. Just a quick intro, is Kendall-Lineker acceptability test skipped? No, of course it's not skipped. When I was talking about Kendall-Lineker and I talked about the acceptability test, I did that on Friday night. So the first 5 minutes of the next lecture, I'm just doing a quick recap to make sure that we've got to the point where we get to. So, of course, we haven't skipped Kendall-Lineker. The acceptability test, we discussed it on Friday. So I don't need to repeat everything I discussed on Friday. It's just a quick recap. All right. So 14.3 says, where the buyer expressly or impliedly makes known to the seller the particular goods, a particular reason why the buyer wants the goods, seller must supply goods fit for that particular purpose. So you can expressly tell the seller why you want the goods. Now, how do you impliedly make it known to the seller a particular purpose? Well, the leading case is priest against last. The buyer bought a hot water bottle. When he first used it, it blew up. The court said, yes, breach of 14.3. What the court said, and this is the important bit, the court said, where the description of the goods points to one purpose only, then goods must be fit for that particular purpose. So you see, you don't need to go and tell the shopkeeper, oh, I'm buying a hot water bottle because when I get home, I'm going to put hot water into it and I'm going to cuddle it to keep warm. No, priest against last is saying, where the description of the goods, hot water bottle, that points to one purpose only, then you have impliedly made it known to the seller why you wanted those goods. Now, another example would be a wool jacket. You buy a jacket, well, the jacket must be fit for wearing. There's no need to say why you are buying a jacket. But if you have unusually sensitive skin and you don't tell the seller, then the seller will not be liable if you contract dermatitis. The authority for that is Griffiths against Peter Conway. Query: if the seller knows that some people contract dermatitis, must the seller warn all buyers? Well, the court said there's a very fine line between what is normal and what is abnormal. If the seller knows quite a few people suffer dermatitis, then this is normal. Then yes, the seller must warn. But if it is a rare disease, the seller cannot possibly know about it. Then it is abnormal. There is no need to warn. Now, of course, these days, you and I know The sellers don't want to take the risk. So the sellers, they just put labels warning of everything. Oh, it contains glutens, it has nuts, it's got lactose, fructose, it contains wool. They just label everything, warning of everything. Remember, packaging and instructions are part of goods. Wormel against RHM Agriculture said that. Goods means not only the goods themselves, but it includes the packaging, instructions, and everything supplied. So if the instructions or the label is not satisfactory or fit, then the goods are unsatisfactory or unfit. This is the same. Now, there are lots and lots of cases that illustrate that where something is so well known, the seller can assume that everyone knows about it. Example, pork. Everyone knows that pork needs to be cooked more than any other meat. So if the seller does not put this in instructions, it's probably okay. No breach. The seller could not reasonably foresee if this particular buyer did not cook the pork thoroughly. This was the case of Hale against Hedges. Another example is underwear. When the buyer buys underwear, he impliedly makes known the purpose. But if the packaging does not say the underwear needs to be washed before wearing it for the first time because there are harmful additives in the cotton, then the underwear would be unsatisfactory, unfit. The buyer could not reasonably be expected to know. The case authority is Grant against Australian Knitting. Now, as I said, 14 sub 3 has two exceptions, where the buyer has expressly or impliedly made known his particular purpose. Seller must provide goods fit for the buyer's particular purpose unless, and there are two exceptions, unless it was unreasonable for the buyer to rely on the seller's skill and judgment, or the buyer does not rely on the seller's skill and judgment. The case authority is S.T. Belton against Tehran Europe. The seller, in this case, sold air compressors to a buyer in Persia. The air compressors were delivered to Persia. The buyer then complained. The buyer said, hey, these air compressors cannot be resold in Persia because of local safety regulations. The buyer said he'd made his purpose known to the seller because he asked the seller for the goods to be delivered in Persia. So this impliedly made it known to the seller that the air compressors would be resold in Persia. And so they need to comply with local regulations. So that's why the buyer said breach of 14.3. The court said, well, yes, the buyer impliedly made it known to the seller the particular purpose for which he required the goods. In other words, for resale in Persia, but there was no breach of 14.3. It's unreasonable for the buyer to rely. The buyer cannot expect the seller to know the safety regulations of all the countries he sells and delivers goods to. Unreasonable for the buyer to rely on the seller's skill and judgment. So the court said no breach of 14.3. What if the seller and the buyer are members of the same trade? Can the buyer ever rely on the seller's skill and judgment? Well, in Kendall against Livico, the court said, oh yes, even if the seller and the buyer are members of the same trade, it is not conclusive that there was no reliance. So even if you're both motor car dealers, you can still rely on the seller's skill and judgment. Let's go back to the case of Ashington Piggeries against Christopher Hill. This is the case about the mink food, which caused liver disease in the mink. The House of Lords said no breach of Section 13. Just because the herring meal was contaminated, it did not alter the identity of the herring meal. It was still herring meal. So no breach of description Section 13, no breach. The buyer was suing for breach of Section 14.3. The buyer said the mink food was not fit for purpose. The seller argued two things. First of all, the seller said, hey, we are not dealers in mink food. This is the first time we'd ever produced mink food. So we are not selling mink food in the course of our business. The second thing the seller argued was that the buyer knew the seller had never supplied mink food before. So the buyer did not rely, or it was unreasonable for the buyer to rely on the seller's skill and judgment. The House of Lords rejected both arguments. The court said, if the seller was willing to accept the order and agree to supply goods, the seller deals in goods of that kind. Secondly, the court said, if the seller knows the purpose of the goods, the presumption is that the buyer relied on the seller's skill and judgment. You see, Section 14 imposes strict liability on the seller, even if the seller was supplying those goods for the first time. Just like the seller in Ashington. The seller never sold mink food before. It does not matter that the seller does not possess the skill and judgment. I know this is harsh on the seller, but of course, the seller is only liable if they actually accept the order for it. Because the seller is essentially holding himself out as capable of exercising sufficient skill and judgment to select goods fit for the particular purpose for which he knows the buyer wants them. Section 14 sub 3 imposes strict liability on the seller. Caveat venditor, caution the seller. Now, we saw the House of Lords case of Kendall against Lilico. We saw that on Friday. This was the case about the Brazilian groundnut extract. The House of Lords used the acceptability test, as you know, and decided that because the buyer would have accepted the extract anyway, if he knew about the poison, there was no breach of 14.2. The extract was satisfactory for the manufacture of animal feed. No breach of 14.2. But the buyer now sued the seller for breach of 14.3, fitness for purpose. House of Lords said, yes, breach of 14.3, because the seller knew that the buyer would resell the extract to the manufacturer of animal feed. Okay, they did not know whether it was for cattle or for poultry. The extract was poisonous to both cattle and poultry in different degrees. The seller is deemed to have asserted that the extract was suitable for cattle and poultry, and the buyer did rely on the seller to supply goods fit for this purpose. That's why there was a breach of 14.3. Just note, obiter, that the House of Lords said, if the effect of the extract on poultry is well known, maybe, for instance, there were loads of trade magazines telling everyone, oh, this extract, shouldn't use it for poultry, or there was industry announcements. Well, maybe if the effect of the extract was well known, then maybe it would be reasonable for the seller to assume that the business buyer who bought the extract for animal feed would not use it for poultry. But the burden of proof is on the seller to show there was no reliance or it was unreasonable for the buyer to rely on the seller's skill and judgment. Just note that the Law Reform Contributory Negligence Act 1945 does not apply to contract claims, only in the tort of negligence claims like misrep. Section 1 of the 1945 Act says damages can be reduced if a party is partly at fault. But 1945 Act does not apply to contract claims. So, if it was reasonable for a buyer to rely on the seller's judgment, just because the seller does not read the trade magazines, he can still claim full damages, no deduction. So, the upshot of all of this is that if goods have only one purpose, the buyer will have impliedly made known his purpose. That's the authority is priest against lust, the hot water bottle. Goods must be fit for that particular purpose. But if goods have a number of purposes, like Ashington Piggeries or like Kendall against Lillico, these cases suggest that goods must be fit for all of those purposes. Now, the responsibility on the seller is a very heavy one under section 14 sub 3. It's very much caveat venditor. Let the seller beware. If you accept the order, then you have asserted you have sufficient skill and knowledge to supply goods fit for that particular buyer's purpose. Partial reliance. Now, what is clear is that reliance on the seller's skill and judgment doesn't even have to be total reliance. Partial reliance is sufficient. The case is Camel Laird against Manganese Bronze. The buyer gave detailed specifications as far as the ship propellers were concerned. Some aspects were left to the seller to decide. One of the propellers was useless. The defect was something not in the buyer's specs. The House of Lords said, breach of 14.3. Partial reliance was enough. So the seller's liability is strict. Now, even if there's no means of detecting the defect, the seller must supply goods fit for the buyer's particular purpose. No excuses at all. Frost against Aylesbury Dairy. This concerned milk which was sold containing typhoid. There was no test for typhoid in those days. Nevertheless, the court held that the seller is in breach of section 14.3. This is what we need to know about sections 14.2 and 14.3. Goods must be of satisfactory quality and fit for purpose. Now, there's a question here that says, I didn't discuss the acceptability test. I think we did on Friday. Because I'll tell you what, during the break, I'll have a quick check because I don't have time to go through it. All right, again, not until we get to, I'll tell you what, whatever, we're going to be doing a problem question later on, all right, today. So what I will do is I'll emphasize a little bit more on this acceptability test then, okay? All right, what we've covered so far, we know enough about 14.2 and 14.3. Goods must be of satisfactory quality and fit for purpose. But note that goods do not have to be fit for every conceivable purpose. If goods are not satisfactory nor fit because of something the buyer did or did not do, then the seller is not in breach of section 14. The case authority is Balmoral against Borealis. Let me tell you about this case. The buyer bought some borosine. Borosine is just a compound to manufacture oil storage tanks. The tanks were no good. I mean, there was just loads of spillage. So the buyer said, breach 14.2, breach 14.3. And the buyer sued for £50 million worth of damages. The court said, on the facts of the case, no breach. The Borosine was suitable for making tanks generally. No breach of 14.2. There was no breach of 14.3 either. The Borosine was fit. The tanks made with the Borosine, the tanks were no good because of the buyer's own production process. The buyer failed to optimize production techniques. The Borosine was fit for purpose. It's just, it was the buyer's own problem. He made the tanks in a way that rendered them useless. It was the buyer's own fault. We'll come back to this case when we look at exclusion clauses. Now, in Lambert against Lewis, the buyer bought a trailer which he attached to a car. The towing attachment was badly designed, and when the buyer was driving, the towing attachment broke. The trailer crashed into the car coming the opposite way. It killed the driver. The dead driver's family sued the buyer for negligence. The buyer sued the seller for breach of Section 14. The House of Lords said, yes, there was a breach of Section 14, but the buyer cannot claim against the seller. See, on the facts of the case, the buyer knew about the defective towing attachment. He knew it for months, but he continued to use the trailer. The buyer was negligent for using it. The buyer must pay the dead driver's family. He cannot claim the sum back against the seller because the loss was too remote a consequence of the seller's breach of contract. The chain of causation had been broken by the buyer's continued use of the goods. He knew the goods were faulty and might cause injury. Okay, so we've covered Section 14. Let's look at Section 15 sample. Now, we don't need to know this in any detail at all, but just note that it is only a sale by sample if there is an express or implied term to that effect. Just because the seller shows a sample to the buyer, that does not make it a sale by sample. It really depends on the intention of the parties. So if I'm a retailer, if I'm a shop, and I go to a wholesaler and I examine a washing machine and I agree to buy one, this is not necessarily a sale by sample because there is no bulk. I'm just buying one. It's just the implied terms, sure, sections 13 and 14. On the other hand, if I am shown one washing machine and I agree to buy 5,000 of them, okay, this is a sale by sample. Section 15 says there is an implied condition that the bulk will correspond with sample in quality, and that the goods are free from any defect not apparent on a reasonable examination of the sample. Example, the 5,000 washing machines delivered, they must correspond with the one I was shown. So it's very straightforward, Section 15, so not much needs to be said. And to be frank, thinking about it, I don't think we'll be setting any exams involving Section 15. At least we haven't done so for the last 20 years. Anyway, it's far too straightforward. So that's all you need to know. All right, let's look at time of delivery. If the contract does not stipulate a time for delivery, the answer then is that delivery must be made within a reasonable time. Just note for now, Section 28 of the CRA. A trader must deliver goods without undue delay and within 30 days after the contract. That's under the CRA for consumers, B2C contracts. Now, if parties do stipulate time in commercial contracts, time is generally of the essence. Leading authority, the Michaelis Angelos. It was a term of the charter party that the ship must be ready to load on the 1st of July. The ship was not ready to load. The court held that this was a repudiatory breach. The charterers were entitled to treat the contract as ended. As you know, from contract law, the charterers were really very lucky indeed, because if the ship had been ready, they would have been the party in breach, because the goods they were going to load were not even ready to be loaded. The goods were miles away. But nevertheless, whoever is in breach first of timers of delivery, that is a repudiatory breach. But just because it is a commercial contract, you still need to look at the facts of each case. If the contract does not expressly stipulate that time is of the essence, you need to look at the nature of the contract and circumstances of the case to see if time really is of the essence. United Scientific against Burnley Borough Council. This case concerned a 15-year lease of property. There were two rent review provisions. One was in year 5 and the other one was in year 10. The landlord forgot to give notice in year 5. So the tenant argued two things. First of all, they said, hey, time was of the essence. And the landlord did not give notice in year 5. So now it's the landlord's problem. He's got to wait until the next review, which is in year 10. The tenant also argued, secondly, even if the landlord could review the new rent should only start when the review is finalised. In other words, it cannot be retrospective. The landlord cannot increase the rent as from the original year 5 review date. The House of Lords said the tenants' arguments were thrown out. The tenants lost. First of all, the court said time is not of the essence unless there was express words in the contract or it was clear from the nature of the contract and circumstance of the case. In this case, there was nothing to indicate that time was of the essence. That's why the court said the landlord can invoke the rent review clause. That right would only be lost if it was equitable to do so, not equitable in this case. The second thing the House of Lords said is that the tenant must pay the new rent from year 5 review date. In other words, retrospectively. The House of Lords said rent is just a contractual payment for the use of the landlord's property. There is no legal reason why a rent review cannot operate retrospectively. So just note that although time is usually of the essence in commercial contracts, United Scientific against Burnley reminds us that it does depend on each case. So if your exam question involves a B2B contract, you need to query whether time really was of the essence based on the facts given. Note, even if time is of the essence, a party can waive his right to treat the breach as a repudiatory breach. If a party waives that right, he cannot go back on it. You will know the case in promissory estoppel, which you studied in contract law, Hartley against Hymans. No need for the facts of Hartley against Hymans, but that case, Hartley against Hymans, is the leading authority for the statement that once a party has waived a breach, he is stopped from going back on that waiver. Of course, having said that, even if a contract term is waived, that waiver doesn't last forever. A party can revive his original right by notice. You will know the case of Charles Ricards against Oppenheim. The buyer ordered a Rolls-Royce chassis. It was agreed that delivery would be by March. It was not ready by March. The buyer kept asking for the chassis. And each time the seller told him, oh, delivery is just a little bit later. 3 months later, June, the buyer wrote to the seller to say, if the chassis is not delivered next month, not delivered in July, forget it. What happened? The chassis was completed in October, and now the buyer refused to take delivery. The seller argued, hey, buyer, you've waived your right to treat late delivery as a repudiated breach. The Court of Appeal said the buyer can refuse to take delivery. Although the buyer had waived his right to treat the contract as at an end, he revived the original right by giving reasonable notice. You see, as I'm saying, in a commercial contract, time is usually of the essence. This is true even if the breach does not appear very serious. Note, please, that section 15 big A, it applies to sections 13, 14, and 15 of the Sale of Goods Act. But no matter how little the breach is, time of delivery is always treated as a breach of condition. And section 15 big A has no application at all to time. This is true even if the reason why the buyer wants to reject is because the price of the goods has just gone through the floor and the buyer just wants a way out of the contract. But hey, this is commercial law. It could be many buyers, many sub-buyers, chain transaction. You can imagine the mess in courts if parties were allowed to give evidence about each other's motives of getting out of the contract. Remember, good faith, bad faith does not come into it. All right, well, this is a good place to take our 10-minute break. When we come back, we will look at buyer's remedies. All right, we'll take a 10-minute break. Hello, everyone. You are absolutely right. Thank you very much indeed. I've checked. I did not go through the acceptability test on Monday. So thank you for raising it this evening. It's a pretty important case, so let me explain it to you now. Now, the acceptability test comes from the House of Lords decision in Kendall against Lilico. In this case, Brazilian groundnut extract was sold by the seller to the buyer. The seller knew the buyer would resell the extract to the manufacturers of animal feed, but he did not know whether the animal feed would be for cattle or poultry. The buyer sold to the sub-buyer. The sub-buyer used it in the manufacture of poultry feed, in other words, to feed pheasants. The latent presence of fungus in the extract made the feed poisonous. Poisonous to both cattle and poultry, but in different degrees. It was lethal to pheasants, so pheasants died. The buyer sued the seller for breach of section 14(2). The House of Lords, a majority decision, said no breach of 14(3). The extract was satisfactory for the manufacture of animal feed. The extract was fit for the usual or normal purpose, in other words, of making animal feed. Now, this decision, of course, has been criticised because the House of Lords, Kendall and Lilico, used the acceptability test. See, the House of Lords said, if the buyer knew that the extract was poisonous to pheasants, the buyer would have accepted the goods anyway, because the buyer could have labelled the goods before selling it to their sub-buyer. So if the buyer would accept the goods, then the goods are satisfactory, no breach. Well, this might be true because if the buyer knew of the poison, sure, he could have labeled, because you know that label forms part of the goods. But the big point is the buyer did not know. That's why surely the goods are unsatisfactory. You see, in Kendall, the House of Lords focused on the usual or normal purpose for which goods are required. That's why the majority House of Lords said the groundnut extract was satisfactory, because it was fit for the most common purpose, in other words, to make animal feed. The extract was fit for feeding cattle, just not suitable for pheasants. The House of Lords said if the buyer had known the extract was poisonous to pheasants, the buyer could easily have labelled. They could have said, warning, no, not suitable for poultry. So you see, the House of Lords used the acceptability test. The test is this: would a buyer with full knowledge of the facts, would he have accepted the goods anyway? If the answer is yes, then the goods are satisfactory. This was the outcome of Kendall. But this approach cannot be right. I mean, it's a bit crazy to ask whether a buyer with full knowledge would have accepted anyway if the buyer did not have full knowledge. The point is, the buyer had no knowledge at all. He did not know that the goods were defective. So why ask what a buyer would have done if he had knowledge when he did not have knowledge? I mean, it just sounds a little bit crazy. I mean, example, I buy a brand new car. Now, I don't know it is in a dangerous condition because let's say one of the nuts in one of the wheels is loose. Is the car satisfactory under the acceptability test? I mean, the House of Lords in Kendall says the test is this: would a buyer with full knowledge of the facts have accepted the goods anyway? So if I knew the nut in the wheel was loose, but it was easy enough to fix, you just need to tighten it a little bit, would I have accepted the car? If the answer is yes, Kendall says the car is satisfactory. Surely this is not right. The main problem with hidden defects is, well, the very fact that the defects are hidden. It is common, of course, to find goods sold which would be dangerous if the buyer did not have information about it. I mean, a good example would be medicine or drugs. It's perfectly safe if the buyer is told about the dosage. In other words, only take 2 tablets with food. I mean, without such information, medicine would be unsatisfactory. So labeling, we know, is very important. This does make sense. It therefore follows that the seller needs to give the buyer adequate information and instructions. It has to be assumed that both the seller and buyer contract with the knowledge of the state of the goods at the time of sale and delivery. Parties are entitled to know where they stand at that time. So therefore, you need to give adequate information and instructions to the buyer. Otherwise, goods are unsatisfactory. The seller in Kendall and Lillico did not give this information to the buyer. That's why the buyer himself did not label or add his own warning to his sub-buyer. Nevertheless, the majority of the House of Lords said the groundnut extract was satisfactory, no breach of 14.2, even though it was poisonous to pheasants. Please do not get bogged down with hidden and latent defects. I mean, Kendall and Lillico, you see, involved a commodities contract. If the acceptability stands as being severely criticised, it may be limited to this type of contract. The modern approach really is on acceptability as judged by the standards of a reasonable person. So I think the way forward for B2B contracts is to focus on Section 15 Big A. In other words, hold that the goods are unsatisfactory, but restrict the business buyer's right to reject under 15 Big A if that defect is trivial or easily rectifiable. I mean, compare to a consumer situation. Now, if the acceptability test exists, and remember, it's been severely criticized, it is very much restricted in a consumer situation. Case authority, shine against general guarantee. The buyer bought a second-hand sports car from the dealer. There were loads of problems. Then the buyer found out that the car had been in an accident before, and they had previously been submerged in water. The court held a reasonable person would not, with that knowledge, have accepted the goods. That's why the seller was in breach. That's what we need to know about the acceptability test under 14.2. Severely criticized. We'll use it when we look at a problem question, and I'll show you how to use it, okay? All right. Thank you for telling me that we didn't cover it on Friday, so I appreciate that. Okay, let's look at buyer's remedies. Now, we will deal with buyer's remedies now and the seller's remedies later on. Now, breach of sections 13 and 14 of the Sale of Goods Act are conditions, subject, of course, to section 15 Big A. The buyer can reject the goods and get his money back, or he can affirm the contract and claim damages. If the buyer wants to reject, the buyer must reject the goods. He can't just sit around and grumble about it to his mother. Otherwise, you might lose your right to reject. The starting point is always section 34. Section 34 says the buyer must be given a reasonable opportunity to examine goods. Now, this right to examine can be waived or excluded by the contract, but it does need to be very clear that the buyer has waived his right to examine, because the buyer is giving up a very valuable right. Once the buyer has had his opportunity to examine for breach of 13, 14, or 15, as I say, the buyer has a choice. The buyer can reject the goods and get his money back and claim damages, or he can affirm the contract and claim damages. Remember section 15 Big A, of course. Even if there is a breach of 13, 14, and 15, section 15 Big A overrides. So the breach of quality, for instance, does not necessarily mean the buyer can reject. Note again, 15 Big A has no application other than sections 13, 14, and 15. So 15 Big A does not apply to stipulations as to time nor express terms of the contract, even if those terms are conditions. It means that even if the seller is 1 minute late in delivering the goods, the court has no discretion at all. 15 Big A does not apply. The common law rules will apply, and time is usually of the essence in commercial contracts. The buyer can reject. It does not matter about good faith, bad faith. For instance, the case we mentioned already is the Michaelis Angelos. The seller could not have delivered even if the ship was ready to load on the 1st of July. It doesn't matter, the court said. The buyer was in breach first because that ship was not ready to load. Of course, if the ship was ready to load and the seller failed to deliver, then it is the seller who would have been in repudiated breach. The buyer's right to reject goods is not the same as the buyer's right to repudiate the contract. It's usually the same, but not always. Let me give you an example. Maybe the seller can re-tender conforming goods within time. So, for instance, if a contract says, oh, the seller can deliver any time next week. Well, if the seller delivers on Monday and the goods are defective, I can reject delivery, but the contract is not repudiated. The seller has time to deliver, retender over the rest of the week, because the contract said the seller can deliver any time that week. Section 35 Big A. Remember, big anything means it's an amendment to the original act. 35 Big A deals with partial rejection. It's very straightforward indeed. Section 35 Big A says, if the buyer has the right to reject some or all of the goods, but he accepts some of the goods, the buyer does not lose his right to reject the non-compliant ones. Buyer has a choice. Very straightforward. Let's look at the buyer's loss of his right to reject. The buyer loses his right to reject under Section 35 in three ways. Firstly, when the buyer expressly intimates he accepts goods. Note that there is one exception to that rule. 35 sub 2 is the exception. 35 sub 2 says, the buyer is not deemed to have accepted the goods which he has not previously examined unless the buyer had a reasonable time to examine. Note, 35 sub 2 only applies where the buyer has not previously examined the goods. So if the buyer has previously examined the goods, the buyer can agree to waive any further examination when the seller delivers the goods. Remember the common law incorporation rules. Buyer must agree to waive further examination either before or at the time the contract is made. If the seller argues that the buyer waived his right to examine by signing a delivery note, delivery notes, the usual sort of thing, I accept the goods are in good condition. If the seller argues that buyer waived his right merely by signing the delivery note, I bet you Section 3 and Section 6 of the Unfair Contract Terms Act won't allow it. The buyer must be given a real opportunity to check that the goods comply with the contract. It is not sufficient that the buyer signs the delivery note when the delivery note is delivered with the goods. Because at the time the buyer takes delivery and he signs the note, it's unlikely the buyer unpacked the goods and examined it at the doorstep of his factory. Unlikely. You see, Section 34 is rule number 1. Section 35 cannot override Section 34. The point is, Section 34 wants to ensure that the buyer has an opportunity to examine the goods. But if the buyer had an opportunity and he agreed in advance not to need to examine the goods again on delivery, courts accept this as the buyer waiving his right to a further examination. Party autonomy wins, but only if the buyer previously had an opportunity to examine. This certainly achieves certainty. So if a business buyer and a business seller, they agree in advance that since the buyer has already previously examined the goods, then there is no further right to examine on delivery. Section 34 simply gives effect to the agreement between the parties. So that's why 35 sub 2 does not apply in these circumstances. It achieves commercial certainty. Parties can agree in advance and the courts will enforce. So the question is, what about prepaid deposits, say for really expensive and exclusive items? Well, what about prepaid deposits? What about it? What's your question? let me carry on with this and you clarify what your question is. The second way the buyer can be deemed to have accepted the goods is if the buyer does an act inconsistent with the seller's ownership. So for instance, if the buyer resold the goods, then the buyer is deemed to have accepted because you can't get the goods back from your sub-buyer. Or for instance, if you use the goods loads and loads of times and for a prolonged period of time, that's because the buyer cannot return the goods in substantially the same condition as when you bought it. So in that situation, again, you've lost your right to reject. In Greg against Emhart Glass, the buyer bought 2 machines. There were loads of design faults, which the seller tried to rectify. This involved factory shutdowns. 2.5 years later, the buyer wanted to reject, and he was claiming £2 million in damages for lost production. The court said there was a breach of Section 14, but the court said the buyer cannot reject. The buyer knew about the defects and he chose to keep the machines. The buyer lost his right to reject. Of course, it doesn't mean the buyer has no remedy. Of course not. The buyer is entitled to damages for all his direct loss, but the buyer cannot reject the machines. So the question here is, exclusive brands will often offer their most loyal customers to buy exclusive goods, but often require them to cough up a hefty deposit even if it has a chance to inspect. Yeah, what about it? Look, I think you are getting very muddled. If you have the right to reject goods, you have the right to reject goods. If you've paid for them in advance, you get your money back. If you haven't paid for them, you no longer need to pay for them. I hope that answers your question. So, we're looking at the ways the buyer can lose his right to reject. The buyer is deemed to have accepted the goods if he does an act inconsistent with the seller's ownership. For instance, by using the goods over a prolonged time. In effect, this merges with the third way that the buyer can lose his right to reject. If the buyer retains goods beyond a reasonable time without rejecting them, the buyer is deemed to have accepted the goods. Whether reasonable time has elapsed, it depends on whether the buyer has had a reasonable opportunity to examine goods to ascertain if they conform with the contract. But this depends, you see, on how complex the goods are. What we're saying is, if you keep the goods beyond a reasonable time without rejecting, you've lost your right to reject. But it does depend on how complex the goods are. So for instance, if I'm buying, a bunch of bananas, well, it's not going to take me very long to examine the goods to see whether they are defective or not. Compare that to, let's say I buy a submarine. I'm clearly going to need a much longer period of time before I know whether this submarine it conforms with the contract or not. Go back to the case we looked at, Bernstein against Panzer Motors. This was one of the brand new car cases we looked at under Section 14, satisfactory quality. The brand new Nissan was delivered to the buyer, but he was an old man and he was ill. So he didn't drive it until he was better 3 weeks later, and he broke down almost straight away. The court said, yes, the car was not of satisfactory quality, but Mr. Bernstein could not reject the car. He had the car beyond a reasonable time in which to examine. He had lost his right to reject under Section 35. Now, of course, I want to tell you that although Mr. Bernstein lost this case, Mr. Bernstein was appealing this case. But just before this case went to the Court of Appeal, it was settled outside the doors of the Court of Appeal. It was settled in Mr. Bernstein's favour. So Panzer Motors gave all the money back to Mr. Bernstein. It kind of indicates that 3 weeks is not really beyond a reasonable time to examine a car, because clearly Pams and Motors, the lawyers for Pams and Motors, must have advised them, look, we think 3 weeks is not that long. So instead of paying the fees for the barrister to argue this point in court, you might as well settle with Mr. Bernstein. But it does stand as a decision. But it does give you an indication that the buyer does not have forever to examine goods. Now, we also saw the case of Bramhill against Edwards. This was the case about the US motorhome, which was 102 inches wide, whereas the maximum permitted on the UK roads was just 100 inches. But the buyer only sued the seller 12 months after he bought the motorhome. 6 months plus 3 months plus 3 months. The court said there was no breach of Section 14 anyway, remember? But obiter, the court said 12 months was way too long. The buyer had lost his right to reject. But note, just because a buyer continues to use the goods, it does not necessarily mean that you have lost the right to reject. See the important case of Clegg against Anderson. Mr. and Mrs. Clegg bought a new yacht. It was expressly agreed that the keel would be in accordance with the manufacturer's standard specifications. When the seller delivered the yacht, they admitted that the keel was heavier than the manufacturer's specifications. But the seller suggested that the buyer try out the yacht anyway. During the next 6 months, the seller and buyer corresponded about what to do as far as the overweight keel was concerned. Mr. and Mrs. Clegg kept asking for the drawings and calculations as to what was proposed so they could take professional advice. The seller only supplied the drawings 6 months after delivery. 3 months later, the buyer wrote to the seller rejecting the yacht. The buyer was suing for the return of his purchase price and damages. The seller argued that the buyers had accepted the yacht because they had the yacht beyond a reasonable time. They had it for more than 6 months. The Court of Appeal said, first of all, the seller was in breach of Section 14(2). A reasonable person would not regard the yacht as satisfactory. The second thing the court said was the buyer had not yet accepted the yacht within Section 35. That's because just because the seller said they liked the yacht, that did not amount to acceptance, because the buyers kept asking, kept saying they wanted certain information before they would decide whether they would accept the yacht or not. When they got the information, the seller only gave it to the buyer 6 months later. The buyer rejected within a reasonable time. They rejected 3 weeks on receiving the report. See also the case of Jones against Gallagher. Mr. and Mrs. Jones wanted to refurbish their kitchen. They were going to have new cupboards and new appliances. They told the kitchen people it must match the existing pine colour. New cupboards were installed. 1 week later, the husband and wife complained that the cupboards did not match the pine colour. The kitchen people said, oh, the wood would age with time and it would become the same colour. There were loads of written correspondence after that about other defects, but there was never a mention again about colour. The kitchen people repaired most of the defects. The next time the husband and wife complained about the colour was 3 months later. 7 weeks after that, the husband and wife got their solicitors to write a letter to say they were rejecting the cupboards. Now it was already 1 week plus 3 months plus 7 weeks. In total, this is now 5 months. The kitchen people argued the buyer had affirmed the contract. The Court of Appeal said, yes, there was a breach, but the contract was affirmed. Mr. and Mrs. Jones have lost their right to reject. You see, the husband and wife could see when the cupboards were delivered, they were not matching colour. They didn't complain until 1 week after installation, and then they tried to reject nearly 5 months later. This was too late, the court said. Interestingly enough, the husband and wife argued, Clegg against Anderson. They said, hey, we were waiting for information just like Mr. and Mrs. Clegg. The court said, this is a completely different situation. In Clegg, Mr. and Mrs. Clegg were waiting for professional information from the seller about what to do with an overweight keel. Whereas in Jones, the husband and wife could easily see the defects right from the start. When the cupboards were delivered, they could see it was already the wrong colour. You don't need an expert to tell them. The court said none of the defects were latent, they were all patent. Now, if goods are bought for resale, then it's a different matter. You see, the seller knows that the business buyer must have a chance to resell those goods to their customers. So when the seller knows the goods are bought for resale, time only starts to run when the buyer has had a chance to resell and the customer has had an opportunity to examine. The authority for that is Truck against Tokmarkides. No need for facts of the case. Note section 35, subsection 6. 35 sub 6 says, the buyer does not lose his right to reject goods merely by letting the seller try to repair them. The House of Lords case authority is Ritchie against Lloyd. There's only the one case on this point. What happened here was that a farmer bought agricultural equipment. When the equipment was delivered, the farmer said, hey, the equipment vibrated violently, badly. The seller took the equipment away for inspection and repair. A few weeks later, the seller told the farmer that the equipment had been repaired. When the farmer asked what was wrong with it, the seller refused to say. But the seller kept saying, oh, the equipment had been repaired to factory specifications. The farmer asked for the engineer's report. The seller refused. The farmer was worried that he would have no chance to test the equipment before the next season, the next year. So the farmer rejected the equipment. The House of Lords said the equipment was not satisfactory nor fit when it was delivered. The buyer's agreement for inspection and repair was not acceptance. That's because section 35 sub 6 specifically says so. But what was important in this case was the House of Lords went on to say that the inspection and repair, that was a sub-agreement. In other words, it was a collateral agreement. And we know Andrews against Hopkinson. We know that from contract law. Just dig your notes out and read up about it. The exact terms of the repair agreement, that will depend on what was agreed. Normally, it would be implied that the buyer won't reject goods during repair. And if the repair was successful, the buyer would accept the goods. The House of Lords said the farmer bought a complex piece of machinery. It was implied that the seller would give information to the buyer if the buyer asked. The court said, in fact, in some circumstances, the seller might give the information after investigation and even before repair. There was a breach of this collateral contract here. The buyer can treat the sub-agreement as repudiated and reject the goods. We're looking at the buyer's remedies. What we're saying is for breach of sections 13, 14, and 15 of the Sale of Goods Act, the buyer can reject goods, get his money back, and he can claim damages. Or the buyer can affirm the contract and claim damages. Note, even if the buyer has lost his right to reject the goods, it is not the end of the world, because the buyer can still claim damages. Now, we need to look at Section 11. Section 11 is quite complex. Read it in your own time. But the effect of Section 11 is that once the buyer has accepted the goods, the breach of a condition can only be treated as a breach of warranty. Now, whether a term is a condition or a warranty in the first place, that will depend anyway on the construction of the contract. Section 11 specifically says even if the contract term is called a warranty, it can be a condition. Now, if contract terms are called conditions, this can be a warranty. You must look at the intention of the parties. We already reminded ourselves of Wickman against Schuler. This is the House of Lords case about the 4-year distribution agreement. All terms in the contract were called conditions. The House of Lords said, no, not all terms were conditions. As I say, we've already reminded ourselves of this case. Remember Lord Atkin in Rowland against Duval. Atkin said, if the seller has no right to sell, then there is no sale at all. So Section 11 can never apply to Section 12 title. This means if there is a breach of Section 12, the buyer cannot accept that breach. In other words, breach of Section 12 is always a condition. That's why in Butterworth against Kingsway Motors, he got 11 months free use. In Barber against NWS Bank, Barber got 20 months free use. They were still entitled to reject for breach of Section 12. We're looking at the buyer's remedies. Let's look at the buyer's claim for damages. Now, you did some remedies in contract law, I know, because I had a look at your manual. Remember, the purpose of damages is not to punish. It is merely to compensate. Case authority, Surrey County Council against Bredero Homes. Now, of course, we know that not every breach will entitle the buyer to reject the goods and terminate the contract. It depends on what that term is, whether it's a condition, a warranty, or it's an intermediate or innominate term. Whatever type of term, the buyer is entitled to damages, whether he rejects or accepts. If the buyer has prepaid, the buyer gets his refund plus damages. Let's look at damages for non-delivery. Now, the buyer is entitled to Section 51 damages in 3 situations. First, where there is no delivery at all. Second, if defective goods are delivered. Or, thirdly, the delivery is late. In these 3 situations, the buyer is entitled to damages for non-delivery under Section 51. Now, Section 51 sets out the presumption of the market price rule. Section 51 says, if there is an available market, damages is the difference between the contract price and the market price when goods ought to have been delivered. If no time was fixed, then the market price is taken at the time of refusal to deliver. An example, a simple one, is on the screen. Let's say the buyer agrees to buy oranges for $1,000. That's the contract price. The seller does not deliver, and the market price is $1,300. Well, the buyer's Section 51 claim is $300. Very straightforward. Market price, contract price difference. Now, it does not matter if the buyer had a sub-buyer for the goods at either more or less than the market price. That's because, you see, the buyer is expected to buy at the market price and resell to his sub-buyer. The authority, Williams against Aegis. No needful facts. Williams and Aegis is a huge case. The House of Lords said, disregard resale price. So if there is an available market, the buyer must sue on the market price rule. Remember, the court has a discretion always to reduce the damages to actual damages if that is less than the market price rule. Now, if there is no available market, maybe because the buyer buys a special one-off machine, then the buyer claims his loss subject to the remoteness rule. You know Hadley against Baxendale. Effectively, this means the buyer is entitled to claim his loss of profit or the cost of repair, as long as the repair cost is reasonable. Look at the case of Ruxley Electronics against Forsyth. Slightly controversial case. This case concerned the construction of a brand new swimming pool and a building. The agreed price was £70,000. It was an express term that the deep end would be 7 foot 6 inches. In fact, when the swimming pool was completed, it was discovered that the deep end was only 6 foot 9 inches. It was 9 inches less deep than agreed. The owner wanted the swimming pool depth rectified. The cost, however, would be £20,000. The House of Lords said it is unreasonable to award £20,000 because this was out of proportion to the benefit to be obtained. The House of Lords awarded the owner £2,500 for loss of amenity only. Otherwise, the court said the owner would gain a gratuitous benefit. In other words, the pool would only have costed £50,000 if the reconstruction was not done. So the court said the appropriate measure is the difference in value which the court assessed at £2,500. Now, this does seem unfair, but the court has a huge discretion when it comes down to awarding damages. In fact, in this case, I can tell you that Mr. Forsyth gave the court an undertaking to spend the damages to actually reconstruct that swimming pool. Mr. Forsyth gave the court the undertaking, but the House of Lords said no. Mr. Forsyth cannot create a loss which did not exist to punish the builders for their breach of contract. The House of Lords was preventing economic wastefulness. Damage is only there to compensate, not to punish. So the point about this case is that if the buyer buys special goods, in other words, there is no available market and the seller is in breach, usually the court will allow the buyer to claim his cost of repair under Section 51, but not always, not if the cost of repair is excessive. Let's look at the date of the assessment of damages. Now, the general rule is this: loss is ascertained at the date of breach, but the court has a huge discretion to limit damages to what the buyer's loss actually is. So courts will sometimes assess the damages at a date after breach. Now, I didn't have this case in your handout, but the case authority is the Golden Victory, 2007. I think you discussed this in contract law. It's a House of Lords case, no need for the facts. Okay, now, Section 51, we've just looked at. Section 51 applies where the buyer rejects the goods. The buyer gets his money back plus Section 51 damages for non-delivery. Now, if the buyer does not reject or he is not entitled to reject, the buyer's claim is for damages for breach of warranty of quality. This is under Section 53. Note that under Section 53, when it refers to breach of warranty of quality, that's what it talks about. But in fact, it applies to any claim for defective goods. So it applies to Sections 13, 14, and 15. Section 53 applies if the buyer does not reject or cannot reject. When is this? Well, essentially in three situations. The buyer cannot reject if, first of all, the buyer has accepted the goods, because, you see, Section 11 says, the breach of a condition is now treated as a breach of warranty only, so you can't reject. The second situation, it's where it's a breach of a warranty anyway. Third situation is where Section 15, big A, applies. Now, Section 53 sets out the presumption of the difference in value rule. Section 53 says damages is the difference between the value of the goods to the buyer and the warranted value. In other words, the value which the goods would have had if they had fulfilled the warranty. Now, I know it sounds a little complex, but it'll be much easier when we handle it the second time, okay? Now, if goods are so defective that the value of the goods to the buyer is zero, basically the buyer recovers the full value. So the effect is more or less the same as rejecting the goods and getting your money back anyway. Now, the difference in value rule, again, it's only a prima facie rule, and it doesn't take much to displace it. One of the leading cases is Bent's Graphics against Fasten. The seller produced vinyl film, which the buyer used to make labels to stick on bulk containers. The buyer then sold these labels to container owners. There was an express term between the seller and the buyer that this film would last in good condition for at least 5 years. The buyer told his sub-buyer that. Of course, the film did not last 5 years. The buyer is now suing the seller for the difference between the value of the goods, which was zero, and the warranted value, which amounted to £560,000, because the buyer was claiming these goods were worthless. But the amount of damages the buyer had to pay his sub-buyer was much less, because amazingly, only one of his sub-buyers complained, and the buyer settled with his sub-buyer. Much less. So the Court of Appeal said the buyer was entitled to his actual loss only. The court said the parties contemplated that the film would be used to manufacture labels, so the natural loss from the breach is the amount the buyer has to compensate its customers. That's why it should be actual loss only, just one sub-buyer settlement. Now, this decision, Bent's Graphics, this decision has been criticised. After all, the seller supplied a worthless product. I mean, maybe, see, the sub-buyer did not sue the buyer because they had very good relationships. Or maybe the sub-buyers would take future business elsewhere. So the buyer ends up losing future profits. And so it ends up giving the seller a windfall because the buyer paid the seller in full for a worthless product. So the seller made over £500,000. Of course, there are criticisms of the criticisms. To award the buyer damages under the difference in value rule would give the buyer a windfall by compensating him for loss which the buyer did not suffer. Sure, if the buyer knew about the defect at the time of delivery, the goods were worth zero. But once the buyer has used the goods for the intended purpose and sold it on for full value, to award the difference in value would mean the buyer essentially gets the raw materials for free. So at the end of the day, the toss-up is let the seller have a windfall or let the buyer have a windfall. The main thing is contract damages are compensatory. It's only meant to compensate a buyer for his loss, not to punish. We're looking at Section 53. Section 53 applies if the buyer does not reject or he cannot reject. Section 53 is easy enough to apply if there is an available market for the goods, because the warranted value is the market value. If there is no available market, then the situation is similar to Section 51. Buyer just claims his normal profit or the cost of repair. Remember, as long as the cost of repair is reasonable. We looked at the Ruxley against Forsyth case about the swimming pool, which was 9 inches less deep than it should have been. In addition to Section 51 and 53, the buyer can also claim consequential losses. Remember, the purpose of damages is not to punish. So if the innocent party does not suffer harm, then very little damages. The innocent party will only get nominal damages, almost nothing. The case authority is Surrey County Council against Brodero Homes. Section 54 is essentially the second limb of Hadley against Baxenden. The general rule is the buyer can recover if the seller knew of special circumstances, and this certainly includes the buyer's loss of repeat or future orders from customers. See the case of GKM against Matborough. The seller sold axles which the buyer used in forklift trucks. The seller told the buyer that the axles were brilliant and can take heavy weight. This was not true. The trucks kept breaking down, and the buyer's customers got really angry, and they refused to give the buyer any repeat orders. Lord Denning said buyer was entitled to damages for loss of future orders. Denning's quote is in the handout. Read that in your own time. Note, it is the type of loss which determines whether a loss is recoverable or not, not the amount. If the loss was not within the reasonable contemplation, no matter how much or how little the loss is, zero is recoverable. Important case, Parsons Livestock against Utley, England. In this case, the seller supplied food storage units to store nuts for the buyer's pigs. The installation chap accidentally left the lid a little bit off. The nuts inside the units went mouldy. One pig comes along, eats the mouldy nuts and died. In fact, 300 pigs ate the nuts and they all died. Huge loss. The Court of Appeal said the damages are recoverable for the dead pigs because it was within the reasonable contemplation of the parties that if the unit was defective, that the food would go mouldy, and the pigs ate it, the pigs might die. Another very good case is Jackson against Royal Bank of Scotland. Jackson imported dog food from Thailand, and he sold it to an English customer. What happened was the English customer would pay Jackson, and Jackson would pay the Thai supplier by LC, by letter of credit, issued by Royal Bank of Scotland, RBS. For 2.5 years, 30 such contracts were completed. Then, by mistake, RBS sent the LC, the letter of credit, to the English customer, who obviously found out how much profit Jackson was making. So the English customer bought direct from the Thai supplier. Jackson was now suing RBS for breach of the contractual obligation of confidence and claiming damages for the lost opportunity of earning profits. The House of Lords said damages was awarded because the loss was the direct result of RBS's breach of contract. That loss was not too remote. It was clearly within the contemplation of the parties. The House of Lords awarded 4 years' worth of lost profits. That was just a figure the House of Lords picked out of the air. Remember, when there is a breach, the injured party can claim damages, but you cannot just sit back and do nothing. You must try and mitigate the loss. In other words, you must do the best you can to cut losses. 2 cases. Keizu against Saunders. The buyer did not pay promptly for goods. This was not a breach of contract, but the seller refused to deliver more goods unless the buyer pays cash. This was a breach of contract. Now, although the market price for the goods was going up, the buyer refused to pay cash. The buyer wanted to sue the seller for Section 51 non-delivery damages, the difference between the market price and the contract price. The court said the buyer was not entitled to damages. He should have accepted the seller's offer. He should have paid cash and then claimed for any loss. This buyer did not mitigate his loss. Of course, the innocent party only has to do what is reasonable. In Roth against Tyler, the seller did not deliver goods, but the buyer did not have cash nor have credit terms with another supplier. So the buyer did not buy in the market, even though prices were going up. The court said here the buyer was entitled to his full loss. The buyer is not expected to go to money lenders and incur high interest. The buyer only has to do what is reasonable to mitigate his loss. The final thing we will talk about before we go on is non-pecuniary loss. The general rule for ordinary people like you and me is that damages is not usually available for distress. I know, yes, there are exceptional cases like the holiday cases, but normally ordinary people are not entitled to stigma damages nor damages for distress. But businesses are dealt with very differently. Courts are more willing to award damages for non-pecuniary losses. 2 cases. Gibbons against Westminster Bank. The bank wrongly bounced a customer's check. Damages was awarded for loss of reputation. You can imagine, can't you? If the bank bounces your check, what are your suppliers going to think? So of course the court said, gosh, with businesses, damages can be awarded for loss of reputation. Anglo-Continental Holidays against Topaldus. A cruise ship owner cancelled the cruise at the very last minute. the travel agency was awarded damages for loss of goodwill. You can imagine, can't you? They've sold loads of packages to their customers and you cancelled the cruise at the last minute. Court said, oh yes, travel agency was awarded damages for loss of goodwill. Just give me another 3 or 4 minutes and I'll finish this, all right? 3 or 4 minutes. Don't forget, the buyer does have other remedies like misrep. And sometimes remedies for misrep is more favorable to the buyer. I mean, for breach of contract, the buyer loses his right to reject if he has accepted the goods. Reject if he has accepted the goods. For misrep, the reject if he reject if he has accepted the goods. For misrep, the buyer to reject if he affirms the contract. The buyer reject if he has accepted the goods. For goodwill. You can imagine, can't you? They've sold loads of packages to their customers and you cancelled the cruise at the last minute. Court said, oh yes, travel agency was awarded damages for loss of goodwill. Just give me another 3 or 4 minutes and I'll finish this, all right? 3 or 4 minutes. Don't forget, the buyer does have other remedies like misrep. And sometimes remedies for misrep is more favorable to the buyer. I mean, for breach of contract, the buyer loses his right to reject if he has accepted the goods. For misrep, they had taken the Lamborghini on hire purchase. And the concept for hire purchase is affirmation. And in Felderall, to reject if he affirms the contract. The buyer gets a longer period of time before he is said to have affirmed. Now, we know the Lamborghini case of Felderall against Hermes Leasing. In that case, the company didn't actually buy the second-hand car outright. They had taken the Lamborghini on hire purchase. And the concept for hire purchase is affirmation. And in Felderall, the MD rejected 5 to 6 weeks after delivery. And the court said, that's not long enough yet to affirm. Compare that with Mr. Bernstein's situation. Remember, he was ill, so he didn't drive his brand new car for 3 weeks. Nevertheless, the court said, 3 weeks, beyond a reasonable time. So affirmation 5-6 weeks, okay. Bernstein, 3 weeks, already not okay. So sometimes the buyer is better off making a claim in misrep rather than under the Sale of Goods Act. Now, with misrep, of course, the primary remedy is rescission, but this is an equitable remedy, so there are bars to rescission. Okay. Now, I'm not going to go into the remedies for misrep because you have all of that under your contract law notes. Just bear in mind also the Law Reform Contributory Negligence Act, 1945. Section 1 says damages can be reduced if a party is partly at fault. In other words, I gave you every opportunity to check the accounts, but you didn't. Remember, the court can reduce the amount of your claim, but that only applies to tortious claims. It will not apply to contractual claims. Specific performance, an equitable remedy. Where the court grants specific performance, remember, the court is telling one party to fulfill his obligations. But courts will only ever grant specific performance if damages is not an adequate remedy. Case authority, Harnett against yielding. So it has to be a special one-off thing, something which is unique. Now, usually, of course, specific performance is not relevant to commercial law. That's because in our commercial situations, our contract is for 1,000 tons of wheat, but the court's not going to grant specific performance. The seller and buyer must buy in the open market. It's just wheat, doesn't matter what it is. We saw 2 cases in contract law, Cohen against Roach. A dealer just bought some antique chairs for investment. The court won't grant specific performance. Now, if a person does not act on the court order for specific performance, then that party is in contempt of court and is liable to a fine and/or imprisonment. Its remedy is purely discretionary. It's similar in a way to injunction, because again, an injunction is at the court's discretion. But this time, the court is stopping one party from doing something. The punishment, again, is contempt of court and a fine and/or imprisonment. Final thing I'm going to mention is conversion. We've talked about the 1977 Act before. Everyone in the chain is liable in conversion to the original owner for wrongfully interfering with his goods. It's strict liability. Okay, that's what we need to know for the implied terms 13, 14, and 15. But it is impossible to answer a question like that without knowing remedies. So what we're going to do is we're certainly going to take our 10-minute break now. When we come back, we're going to look at that question on page 52 of your handout. So what would be helpful is if during this break, you read this question to yourself. Just read it and think about it. When we come back after the break, I will read this question just once, and then we'll get down and do it. All right, so let's take a 10-minute break. 10-minute break. Okay, hi. Let's look at this question. Very typical exam question, and it comes up every year. All right, so let's read the question just once on page 52. I hope you had a chance to read it during the break anyway. So let's read this question on page 52 in your handout. Mary decides to purchase a new industrial-sized washing machine for her laundrette. She recalls the previous week's trade journal in which Shabby Appliances were advertising the latest super eco-friendly and energy-efficient heavy-duty fast spin 200 washing machine for a knockdown price of £3,000. The usual price was £5,000. On the 10th of January, Mary decides to visit her local Shabby Appliances to find out more, where Peter, the salesman, being rather persuasive, offers her a generous part exchange allowance on one of her old machines and a free 1-year extension to the standard 2-year manufacturer's warranty should Mary buy a new Fastspin 200 today, which she agrees to do. The Fastspin 200 is delivered and installed the next day. Mary immediately removes the packaging and is disappointed to note a number of deep and pronounced scratches on all sides of the machine. There is also water present inside the drum, as well as some items of children's clothing indicating previous use. Not wanting to make a fuss, she overlooks these issues and is reasonably satisfied with the Fastspin 200 until she discovers the following: water leakage during each washing cycle. The door regularly jams, making it difficult for customers to open. The machine is slow and often stops during each use. And far from being energy efficient, her electricity bills for this particular machine are considerably more than for the machine she replaced. On the 26th of January, Mary contacts Shabby to raise her concerns about these defects. Whilst largely unsympathetic, they reluctantly agree to collect the machine and repair any obvious and easily fixable problem or problems. They collect it the next day. On the 30th of January, Shabby returned the Fastspin 200, claiming it has been repaired, but refusing to explain what the problem was. Shortly after, it stops working altogether, at which point Shabby refused to offer any further assistance and refer Mary to her manufacturer's warranty. Advise Mary in relation to any potential breaches of Section 13 and 14 of the Sale of Goods Act. Okay, so I'm hoping you've read this during the break. Now, Mary wants to know what her rights and obligations are as far as the new machine she has bought. The question specifically asks you to discuss sections 13 and 14 of the Sale of Goods Act. Let's do rough work. Okay, the first thing to do is you write down the things that our client is complaining about. She's got lots of complaints, hasn't she? What is Mary, our client, complaining about? Literally just write down, as your rough work, write down what her complaints are. You tell me. You tell me. What is she complaining about? What's wrong with the thing that she's bought? What's wrong? What's she complaining about? You tell me. She has to be complaining about something. Otherwise, she's not going to need to ask us for advice. So what's she complaining about? Yeah, she's complaining about scratches. Oh, by the way, one student recommended right at the beginning that I use this funny drawing pen underneath the pen. I'm using that now, and I think it's better. So thank you for that suggestion. I appreciate that. Okay, scratch marks. Yeah, definitely. What else? Oh, yeah, there's a water leakage. Yeah, there's a water leakage. What else? What else is there? Not energy efficient. Okay, not energy efficient. Anything else? Door jams. Door jams. That's no good. Anything else? Yeah, jamming door. Anything else? Well, I've written jamming door. Yes, slow. It often stops. What else? Anything else? Yeah, you're right. All these things. Not energy efficient. Yeah, it's not eco-friendly. It's none of those things, right? Now, the point is she's got lots of complaints. So what you do is you write down the stuff that she's complaining about. So at the end of the day, you'll end up with a list of things that she's complaining about. Now, of course, some of these things will be a breach of description, and some of it will be a breach of quality. Some of it will be a breach of fitness. Now, there are different ways you can answer this question. You could discuss each complaint separately. So you would discuss complaint number 1, Then you move into complaint number 2, or you could group the complaints into relevant components. We know the question is about section 13 and section 14. So I reckon it's probably easier if the complaints are handled as a group. So in my rough work, I would just write next to each of these complaints where I'm going to discuss it. For instance, right, give you an example. One complaint is that she says the machine has deep scratches. You tell me, is that a section 13 or is that a section 14? One of Mary's complaints is, the machine has deep scratches. You tell me, is that 13 or 14? Is that 13 or 14? Deep scratches. I agree with you. 100%. It is section 14. Is it 14.2 or 14.3 or both? Is it 14.2 or 14.3 or both? You tell me. I agree with you. It is 14. I agree. Is it 14.2 quality, 14.3 fitness, or is it both? What do you think? What is it we need to discuss as far as the deep scratch is concerned? 100%, you are correct. Very, very good. That is exactly right. I agree with you. So this is 14.2. Well done. It's absolutely correct. Thank you. Now, the machine, you see, the washing machine with scratches, is it satisfactory to a reasonable person? Because the machine can be used as a washing machine. So it's not a matter of fitness. It's not a 14.3 issue, just 14.2. You're correct. So what about the other complaints? You see, you've got to run through it very quickly because then we can group the complaints together. In other words, when I talk about satisfactory quality, I want to mention all the complaints which fall within satisfactory quality. When I discuss fitness for purpose under 14.3, I want to deal with all the complaints that fall with fitness. Okay, so that's what I'm just doing in my rough work. Okay, so what about the machine not being new? What about her second complaint? Hey, the machine's not even new. It's got clothes inside. What's that? Breach of what is that? What is that? 13, 14, what is it? It's got to be 13 or 14 because that's what we've been asked to advise about. What about the machine not being new? What do you think that is? What do we need to discuss? 13, 14, what do we need to discuss? You tell me. The machine is not new. What's that? What do we need to discuss? Yes, very good. Section 13. The answer is not 14.2a. You only discuss 14.2a when 14.2 applies. Not being new is a matter of description. It is section 13. Except I'm going to write 13, but I can't really write 13 because, you see, you can't ever jump into discussing section 13. What is it you need to establish first? You have to establish there's a sale by description anyway. You have to establish that. You can't just talk about 13. Impossible. 13 only applies if one thing. Thank you very much indeed. Super. That's a really correct answer. The answer is there needs to be an express term as to description. Only then does section 13 kick in. So here, before we can even talk about the section 13, we have to discuss whether there is a term of the contract as to description. Okay? I'm only doing rough work. I'll do the whole thing, later on. Okay. What about leakage during use? That's her third complaint. What about the leakage during use? Breach of what is that? 13 or 14? The machine's leaking when it's used. 14, I agree with you. Is it 14.2 or 14.3 or both? I agree with you there as well. Thank you very much. Super. This is the correct answer. The answer is 14 both. So we're talking about 14.2 and 14.3. It's both 14.2 and 14.3. Mary then says, oh, the machine is very slow. Very slow. What do we need to discuss there? The machine, oh, actually, look, door jams. Well, the door jams is obviously the same as 14.2 and 14.3 as well, right? So the door jams is exactly the same. This one and this one. What about, oh, she says it's very slow. What do we need to discuss? She says, oh, it's very slow and it often stops. It's very slow. It often stops. What do you think? What do we need to discuss? I mean, in a way, I mean, she's complaining it's very slow, isn't she? In a way, we need to know whether there was anything said or agreed about the machine's speed. I mean, the trade journal does call the machine fast spin. I mean, I'm wondering if that's just the manufacturer making up a model name for the machine, or whether it's really supposed to be fast. I don't know. Maybe we need to discuss description. I agree. We can't be sure it's a term of the contract anyway, can we? So again, it's part back to the situation when we can't be sure it's even a term of the contract, let alone section 13. I mean, we might need to discuss whether a statement that the machine is supposed to be fast, you see, it might only be a representation. Well, I think we should just put that down for now as rough work, and we'll see where we are when we come to do the full answer. So what I'm going to write down for very slow is I'm going to write down terms versus representation. Because if it's a term of the contract, okay, it's an express term, then I can talk about section 13. It's supposed to be very fast. If it's not a term of the contract, then maybe it's merely a representation. And of course, if it's a representation, no need to discuss section 13. But the other issue is you don't have a whole conversation on misrep. This is a commercial law exam, not a contract law exam. So we want you to mention misrep in like one sentence, all right? Don't have time for anything more than that. So it's saying it's very slow and it often stops during use. Well, I agree. I think it's probably a section 14 issue as well. I agree. No, that's the whole point. It often stops. Well, I think that's also a section 14. I agree with you. I think it's probably both 14.2 and 14.3. I mean, how can it just stop like that? I mean, it's not satisfactory, it can't be fit, can it? So I agree with you. I'm going to write down, so terms versus rep might lead to section 13. It might also be section 14.2 and 14.3. Okay. What about the last bit? Oh, the machine is supposed to be eco-friendly and not very energy efficient. Well, in a way, yeah, well, in a way that kind of sounds similar to us saying the machine is being slow. So I think eco-friendly, energy efficient, I think that's the same as this one. I think it's wonder whether it's a term or representation. If it's a term, it might be 13, but either way, you know, if it's not eco-friendly, maybe it's a satisfactory quality issue. We're not sure, but it's kind of lumbered all in one. So a little bit neater than that is probably this. Okay, so once you've done that, we can now plan the answer. You see, I've written down the problems our client is complaining about. I've written down the aspects of law that we need to discuss in relation to each of those complaints. Now I know we've been asked to check on possible breaches of sections 13 and 14 of the Sale of Goods Act. I'm trying to plan my answer here. So what is it we need to check? I mean, we do need to check that it is the Sale of Goods Act that applies. I know the question says possible breaches of 13 and 14 of the Sale of Goods Act, but you need to check that the Sale of Goods Act applies anyway. And how do we do that? How do we know if the Sale of Goods Act applies? You tell me. How do we know whether the Sale of Goods Act is the act that applies to this contract? How do we work on that? It's not because it's B2B. It's not because of that at all. Ultimately, it leads to it, but it's not the answer. Answer is not because it's B2B. No, it's not. Answer is not section 2 sub 1 either. It's only if the Sale of Goods Act applies, then you look at section 2 sub 1 to make sure it's not the Supply of Goods and Services Act. But the starting point, the starting point is that you've got to make sure the CRA does not apply. That's what you've got to go through. So in order to check whether it is the Sale of Goods Act applies, you need to check that the CRA does not apply. So you need to go through the definition of a consumer contract. If it's not a consumer contract, then it is the Sale of Goods Act that applies. So in your introduction, you need to work out whether it is the CRA that applies or not. If the CRA does not apply, then either it is the 1982 Act, which is our next topic anyway, that's the Supply of Goods and Services Act, or it is the Sale of Goods Act. It's one of the other two. Now, of course, you're given the clue, aren't you, that it is going to be the Sale of Goods Act that applies. But you have to check for yourself. When does the Sale of Goods Act apply? Well, that's when the CRA does not apply. In other words, it's not a consumer contract. If it's not a consumer contract, then it is the Sale of Goods Act that probably applies. Now, if the Sale of Goods Act applies, then sure, you're right. Section 13, section 14 are the implied terms. But you see, hang on a second. It's not guaranteed that the Sale of Goods Act applies. Because the Sale of Goods Act, as you say, only applies if section 2 sub 1 is satisfied. In other words, where there is a contract for the sale of goods. In other words, where goods is the substance of the contract. Why am I querying this in this question? What are you told that makes you think, oh, I better check this as well? Remember, I'm not doing the whole answer. I'm just doing the rough work right now. I'm just trying to see, trying to plan my answer. I'm trying to do my intro. My intro has to make sure it's a Sale of Goods Act. I know it's not going to be the CRA because I can define that and sort that out. But you have to be a bit careful here. You need to make sure it's not the Supply of Goods and Services Act 1982, which is in fact a topic in our next topic after this. And Sale of Goods and the 1982 Act questions come up every year as well. So why do I need to query this? What am I told in this question that makes me think, I wonder if it is the Sale of Goods Act or whether it's the 1982 Act? Well, let me tell you, because we haven't done the 1982 Act yet. All right. Now, the Sale of Goods Act only applies where goods is the substance of the contract. The reason why I am querying this in this question is because we are told that Mary has part exchanged her old washing machine. Not only that, what else? Well, we're not told who did the installation. You see, if it was shabby, was the installation or the washing machine the substantial element of the contract? Because if it was the installation, which was the major part of the contract, then we're talking about the 1982 Act. Of course, exam technique tells you this will be a Sale of Goods contract because you are asked to advise on sections 13 and 14 of the Sale of Goods Act. But you do need to query this piece. I'm not talking about writing a whole page essay. I'm talking about an introductory 1 or 2 lines. Not just you need to query, not just because it is an exam question, not just because it's exam technique, but also when you are a qualified lawyer. If a client tells you, or to be frank, a fellow lawyer, they tell you to advise on the Sale of Goods Act, you satisfy yourself that it is the Sale of Goods Act that applies. Anyway, in this question, we need to have an introduction which confirms that it is the Sale of Goods Act that applies, not the CRA, not the Supply of Goods and Services Act. I know we haven't covered the 1982 Act yet, but we will. It's our next topic and it comes up every year. So in this question, we're going to put this in the intro and we're going to conclude that, yeah, it is the Sale of Goods Act that applies to this question. All right, so I'm planning my answer here. All right, it's so worth spending time planning your answer, because once you've planned your answer, the answer actually just flows. It's much more easy to handle. Doing rough work takes 5 to 10 minutes. I know it's the first time we're doing it, so it always takes ages, but usually there's a template. All right, 5-10 minutes, that's all it takes, not more than that. And then you've got 50 minutes to write down the entire answer. So after you've done your introduction, then we can discuss description. Now, remember, you cannot go straight into section 13. So although you are desperate to discuss description, you cannot discuss section 13 first. What is it you need to establish first? As we said, there needs to be an express term as to description. But even though sometimes you need to discuss whether what was said was a term anyway, because sometimes it's only a representation, in which event the Sale of Goods Act implied terms don't come in at all. Now, I know, of course, we need to discuss this description, terms versus representations. If it is a term, then we need to say it's an express term, and then we can talk about section 13. Now, we can then discuss, we know, satisfactory quality and fitness for purpose. That's true. But one thing you need to establish first. Section 14 does not always apply, does it? You can't jump in and discuss 14.2 and 14.3. Why? Because 14.2 and 14.3 only applies if what? Section 14 doesn't apply to every contract. 14.2 and 14.3 only applies if what? Thank you very much. Correct. The answer is only if the seller sells in the course of business. So you have to make that point, that this seller sells in the course of business. Now, of course, your exam seller will always be selling in the course of business. Otherwise, your answer will be very, very short. But just remember to establish that little detail before you get into the full-blown conversation about 14.2 and 14.3. So once you've established course of business, now you can talk about 14.2 and 14.3. Now, remember, of course, that 14.2 has 2 exceptions. 14.3 also has 2 exceptions. Now, because I can't write everything down, this is just my rough work. I don't want to waste too much time writing all words and stuff. So what I normally do, under 14.2, I put 2 prongs, 2 fingers. 2 fingers because it reminds me when I'm writing my answer that I talk about 14.2 and then immediately talk about the exceptions. All right. So 14.2 have 2 exceptions. 14.3 also has 2 exceptions. I just do 2 fingers like that. So I remember the 2 things I need to talk about and get rid of. Because remember, the exceptions don't apply. We don't want them to, because if they do apply, again, our answer will be very, very short. So after you have established that the seller is in breach, now what you need to discuss. All right, so we've gone through, we're going to be discussing description, we're going to be discussing 14.2 and 14.3, and of course, Will we find a breach? Will we find a breach? The answer is yes, of course we're going to find a breach. Otherwise, again, if there's no breach, then what are you complaining about? So of course it's going to be a breach. So after we discuss the breach, then what do we need to discuss? You tell me. What do we now need to discuss? After the breach, what do we discuss? Can't be the end of the answer. Just because you found a breach, so what? You're advising your client. What does your client want to know? What do you guys say? Yeah, 100%. Exactly right. Of course the client wants to know about remedies. Of course. But we can't jump into remedies. We can't jump into remedies because we need to know one thing. I know there's a breach. That bit I agree. But before we jump into remedies, we need to know one thing. We need to know whether our client, Mary, has accepted the goods or not. Because, you see, if she has not accepted the goods, she can reject the goods and claim damages. Of course, if she has accepted the goods, then she cannot reject, although she can still claim damages. So before you discuss remedies, you need to establish whether she can still reject or whether she has accepted the goods. So yes, we must talk about remedies, but before you discuss remedies, you've got to discuss acceptance. Because that affects your remedies. So you can't talk about remedies until you know whether the client has accepted the goods or not. Because remember, once you've accepted the goods, then you're not entitled to certain amount of damages. All right. So, and the way I look at remedies, and remember, remedies is ultimately what any client wants to know. Well, the way I look at remedies is it comes in a pack. What I mean by a pack is that remedies, I think, includes 5 things as a standard thing. Now, the neater version is what I've got on screen now. It's a neater version. So just give me 1 second. Okay, the neater version is up on screen now. That's what my rough work would look like. It won't take me more than 5-10 minutes, not even 10 minutes, because it's standard, all right? And this is a kind of template, which means, you know, questions are always like this. So I don't think it'll take me more than, to be frank, I think 5 minutes. That's all it's going to take me to do that. So now I've got 55 minutes to answer the question in full. All right, so now let's do that, all right? So we've done the rough work. This is the pattern. This is how my answer is going to go. Let's just answer this question in full. Now, the first thing we said you need to establish is whether this is a sale of goods at situation anyway. You do that by checking if the CRA does or does not apply. We haven't done the CRA yet, but we've already done the introduction to it. The CRA only applies to consumer contracts. What is a consumer contract? It's a contract whereby a trader supplies goods, digital content, or services to a consumer. The definition of who these people are is in section 2 of the CRA. The trader is someone who acts in the course of business. Shabby is definitely a trader, so that condition is satisfied. Who is a consumer? Well, section 2 says a consumer must be an individual natural person. Well, Mary sounds like she's a natural person. I mean, we're not told she's a company or anything. So she is an individual, but businesses cannot be consumers. We're told that Mary buys an industrial washing machine for business use. So she's running a laundrette business. So Mary is not a consumer. Conclude. CRA does not apply. We now need to ensure that it is the Sale of Goods Act which will apply to her contract for the purchase of the washing machine, we need to check two things. First of all, Sale of Goods Act only applies if Section 2, sub 1 is satisfied. It needs to be a contract whereby the seller transfers or agrees to transfer the property and the goods to the buyer for a money consideration called the price. Now, the washing machine is clearly goods under Section 61, but the Sale of Goods Act only applies where there is money consideration. So if there's no money involved, it is not a contract for the sale of goods. You see, in this question, we're told that Mary traded in her old washing machine. Now, where goods are exchanged for goods plus money, is this a contract of sale? Well, answer is, it depends. You could look at the substance of the contract. Is money or goods exchanged the substantial consideration? I mean, ultimately, it depends, of course, on the intention of the parties. I mean, Mary is trading in her old washing machine in part exchange for a new one. Usually, parties intend for the new machine to be a contract of sale. In other words, the Sale of Goods Act would apply. Query, actually. I mean, we're not told, are we, how much money Mary paid on top of the trade-in allowance. The point is, as long as some money is involved, the Sale of Goods Act will apply. We know, you see, that consideration need not be adequate, but it must be sufficient. So as long as even 10 cents is involved, great, Sale of Goods Act can apply. The second thing you needed to check in this exam question is who installed the washing machine. You see, it's not absolutely clear here because we're just told that the machine is delivered and installed the next day. I mean, did Shabby do the installation? You see, we're querying whether the contract falls within the Sale of Goods Act or the Supply of Goods and Services Act 1982. Because if the installation is only a small part, it's only incidental to the sale of the washing machine, then sure, the 1979 Act will more likely to apply. But if the installation is a major part, then the contract will not fall within the Sale of Goods Act, but within the Supply of Goods and Services Act 1982. In this question, it's just installation of a washing machine. I mean, the service element doesn't appear to be too substantial, does it? So I think it will be a Sale of Goods Act. Having established that, we know Mary has lots of complaints. Now, the question is whether what she is complaining about amount to breaches of the terms of the contract. We are specifically asked to advise on sections 13 and 14. Tell Mary straight away that if there is a breach of 13 and 14, these are implied conditions entitling Mary to reject the machine. Hang on a second. We should mention one thing. We didn't even put it down in the rough work, but we ought to. Breach of sections 13 and 14. They're not always a breach of a condition. When is a breach of sections 13 and 14 not a breach of a condition? Wonderful, very good. The answer is when the court exercises section 15 big A discretion. Remember, 15 big A overrides sections 13 and 14. You're answering this question really well. Pretty exciting, considering we've only just covered it. So it's very exciting you're getting the right answers. Section 15 big A overrides 13 and 14. So if the breach is so slight that it is unreasonable for the buyer to reject. The breach of a condition can be treated as a breach of warranty only. The burden of proof, of course, is on the seller, Shabby. So what I'm going to do here is I've got to make sure I mention 15 big A. Maybe I'll do that as part of the intro. All right? So now, of course, having done the introduction, and that's all I've done, making sure it's not the CRA, making sure it's not the 1982 Act, I'm now confirming that it is the Sale of Goods Act, and our concentration is on 13 and 14. I'm explaining to our clients straight away, if we do find a breach of 13 and 14, these are implied conditions subject to 15 big A. That is my introduction. Now, and that's a standard introduction. Now, of course, having done that, you can deal with each bit in order. Now, there are various ways you can do this. I mean, what I've done, my preference is to do section 13 first. I discuss section 13, bringing in all these complaints she's got, and then I discuss section 14. But only because that's how we handled it in our lectures. You can deal with section 14 first if you want. It makes no difference. As long as you cover the same issues, it doesn't matter whether you deal with 14 first and then 13 or 13 plus 14. It's up to you. You deal with the issues, you will get the marks. Now, I'm just going to start with description because as far as I'm concerned, 13 comes before 14 and it's how we handle the lectures. So I'm just going to deal with description first. So say straight away that section 13 says it is an implied condition that where goods are sold by description, goods must correspond with that description. Explain that in order for section 13 to kick in, there must be an express term as a description because goods need to be sold by description. Just because the seller says something or his catalog says something, it does not necessarily mean goods are sold by description. I mean, we are told, aren't we? In the advert in the trade journal, Shabby said the washing machine was new and super eco-friendly and energy efficient. And it was described as Fastspin 200. Well, not every statement about the quality or fitness can be treated as part of description. Sometimes it is only a representation. And it is very important to distinguish whether a statement is a term or a representation because you know that the remedies are very different. So how do we know whether a statement is a term or representation? Well, the answer is the main test is it depends on the intention of the parties. Now, you know there are 5 factors the courts bear in mind to determine whether a statement amounts to a term or a representation. In the exam, don't mention all of them. Just highlight the ones you feel are relevant. You've got to watch your time. This will limit what you can and cannot include in your answer. The really important thing is to tie in what you say to the question asked. Now, we are told that Shabby made statements in a trade journal. That said that the washing machine was super eco-friendly and energy efficient. Can statements in adverts amount to descriptive terms? Well, the answer is yes, because we looked at the case of Beale against Taylor. A car was advertised as 1961 white Herald convertible. The court said the words in the advert did amount to terms of the contract, but not always. Compare that with the case of Mrs. Brewer against Mann. Now, we're looking at whether or not what was said amounts to terms of the contract. There are factors the court will take into account. One factor, an important factor, is reliance. In order for eco-friendly, super efficient, in order for those words to amount to a term of the contract, the description must be influential in the sale so as to become a term of the contract. If Mary did not rely or was not influenced by that description, then the parties did not intend for that description to be a term of the contract. Harlington and Leinster against Christopher Hull go through the facts of this important case. The seller sold 2 paintings to the buyer, which the seller said were by the German artist called Munter. After the sale, the buyer realized the paintings were not by Munter. The buyer sued for breach of Section 13. The court held there was no breach. The buyers were the world's experts on Munter paintings. The buyer did not rely on the seller's description. They relied on their own expertise. Tie this into this question because you see, your question specifically tells you that Peter, the salesman, was very persuasive. Now, of course, we are assuming that Mary did not enter into the contract purely because Peter offered her a free 1-year extension to the standard manufacturer's warranty. Because if she did, then she did not rely on some of the other statements made. So, assuming the 1-year extension was just one factor why she bought the washing machine, we can still argue that she contracted on the basis that the washing machine advertised was new, super eco-friendly, energy efficient, and fast. New, of course, is likely to be a term of the contract anyway. We even know a case specifically on this. Remember Andrews against Singer. The contract was for new Singer cars. Now, there is no need to go through the entire facts of the case. All you want to say is that when the buyer in Andrews against Singer contracted to buy new Singer cars, the court held that new was an express term of the contract. Same as Mary's contract is for a new washing machine. So new will be an express term as a description. Well, I'm not sure about energy efficient and fast though. Maybe those words are only a representation. I mean, if the representation is false, then it might amount to an actionable misrep. Now, there is no need to say anything more about misrep. I mean, you could discuss this later if you have a few minutes left, because you are asked specifically to advise on 13 and 14, so you want to concentrate on that. You mentioned the fact that those words, they might be just a representation, and it might amount to an actual misrep, but as I say, no need to discuss it any further. But now you've said we've worked out that we do have a term of the contract because the washing machine must be new, then this is an express term as a description. The washing machine, as it turns out, is not new. I mean, it had someone else's clothes in it, for heaven's sake. So there's definitely a breach of the express term that the machine must be new. All right, we've done a lot. What we're going to do is we're going to end the lecture here. When we come back tomorrow, we are going to continue and complete the full answer to this question. All right, so we'll end here and I will see you tomorrow. We will start off straight away completing, answering this question. All right, I'll see you guys tomorrow. Okay, good night.